Today on Forbes, why the Supreme Court's attack on federal agencies is a boon for crypto. As the biggest names in crypto remain embroiled in years-long legal battles with federal regulators, the Supreme Court has delivered them a gift: 3 landmark decisions weakening the powers of those same federal agencies. That, plus the possibility of a crypto-friendly second Trump administration and movement in Congress on pro-crypto legislation, are providing tailwinds for the industry. First, on June 27th, in a 6-3 decision, the conservative majority of the Supreme Court decided in Securities and Exchange Commission v. Jarkessi that when the SEC seeks to fine organizations for fraud without pursuing criminal charges, it must do so in federal courts instead of relying on its own administrative law judges. Under Chairman Gary Gensler, the SEC has made cracking down on the crypto industry a priority. According to an analysis by Cornerstone Research, the SEC brought a record 46 enforcement actions against digital asset firms in 2023, with 20 of them, up from 6 in 2022, resolved as administrative proceedings. Most of the litigations, 20 of 26, alleged fraud, but so did 6 of the crypto administrative cases, according to the analysis. The new limit on administrative law judges doesn't directly affect SEC cases against such high-profile players as asset exchanges Coinbase and Kraken, developer of XRP blockchain Ripple, and decentralized protocol Uniswap. They're already in federal court. But it does cramp the SEC's enforcement resources and style. A day later, on June 28th, in Loper Bright Enterprises v. Raimondo, the same 6-3 Supreme Court majority overturned so-called Chevron deference, a 40-year-old legal precedent holding that courts should defer to federal agencies' reasonable interpretations of ambiguous language in the laws Congress has passed. In its new ruling, the court held that the Administrative Procedure Act requires judges themselves to independently interpret the meaning of ambiguous wording, rather than deferring to agency officials. And finally, on July 1st, in Corner Post Inc. v. Board of Governors of the Federal Reserve System, the court's conservatives extended the time frame during which businesses can challenge an agency's rules, opening up the door for decades-old regulations to be called into question by new businesses. And what are crypto businesses, if not new? Beyond the impact on any single case, the decisions, taken together, sent an unmistakable message. The legal tide has turned against the regulators, including those intent on holding crypto back. Paul Grewal, chief legal officer for crypto exchange Coinbase, said of the decisions, quote, "What we're seeing is a culmination of deep skepticism of agency overreach that's been building over not just the last couple of terms, but really over the last couple of decades. The best example of that is Loper Bright, where you've seen a complete reconceptualization of the role of agencies in interpreting congressional mandates." The Loper Bright decision is quite a consequential overturning of precedent and could eventually come to play a role in a convoluted but potentially significant crypto industry court fight. Custodia Bank's lawsuit against the Federal Reserve Bank of Kansas City and the Federal Reserve Board, seeking to gain a coveted, quote, master account. Both crypto and fintech startups have been frustrated in their quest to get these master accounts, which provide direct access to the so-called payment rails banks use to move money to other banks on behalf of their customers. The systems include FedWire, which handles one-time wire transfers, and the recently launched FedNow real-time payment system, which could eventually give businesses and consumers near-instant access to payments, including paychecks, and money moving between financial accounts. If fintech and crypto firms can't get master accounts, they'll have to go through traditional bank partners to move money, potentially stifling innovation, or at least their profits, since they'll have to kick back part of their fees to traditional banks. In the worst case for newcomers, regulators could pressure traditional banks not to work with them, denying the upstarts even indirect access to the nation's payment system, a barrier Custodia says it has run into. The business stakes and opportunities here are substantial, because 2 of the biggest U.S. banks who serviced crypto clients, Silvergate Bank and Signature Bank, failed during the March 2023 regional banking crisis. Hardly any banks have stepped up since to fill the void. For full coverage, check out Emily Mason's piece, on forbes.com. This is Kieran Meadows from Forbes. Thanks for tuning in.